So, for example, in D.C., in relation to the Pants case, all Mr. Pearson had to allege was a statement by my clients in relation to this satisfaction guaranteed sign that he could allege had a tendency to mislead. So, first of all, no real proof requirements of a false statement. Second of all, there's no intent to deceive required. So my clients didn't have to intend to deceive anyone in relation to that sign, that satisfaction guaranteed sign. There are a lot of states, in fact, that don't require this intent to deceive. Arizona, Connecticut, Georgia, Massachusetts, Minnesota, North Carolina, Ohio, Texas, D.C. A lot of these jurisdictions do not require that intent to deceive. Third of all, reliance. A lot of states don't require that, for example, Mr. Pearson had relied on my client's statement to his detriment, or to require him to actually believe what was being said. And there are at least 12 states that, in fact, in their Consumer Protection Acts don't require that reliance. And baffling enough, number 4, there's no actual harm that's necessarily required in some of these Consumer Protection Acts. So you don't even have to necessarily be harmed in any sort of way, and you can bring a lawsuit like this, potentially claiming the type of damages that Mr. Pearson did. In a lot of states, there's no requirement to certify a class action. For example, in D.C., Mr. Pearson could very well have decided to bring his case on behalf of 20,000 citizens of D.C. that he believed might have seen this satisfaction guaranteed sign. No requirement to certify the class action, but he, Roy Pearson, could have recovered on behalf of all of those 20,000 people. So these are baffling statutes, and the magnitude of how they can damage not only small business but also big business, from common carriers to pharmaceutical companies to anyone that has speech in the public domain, is immense. And finally, the penalties in Consumer Protection Acts are likewise very large, and that's how we got to that $54 million figure with Mr. Pearson. Is you've got the ability to triple your damages for each violation that you allege. You have the ability to claim attorney's fees to the extent that you win any little bit of your case, and you also have a vast ability to allege and claim punitive damages. That's how we got to the $54 million. But this case isn't an anomaly, very importantly, and there are a lot of cases all over the country, and there are a lot of cases, particularly in the District of Columbia right now, where large business is being targeted by trial lawyers because they understand not only the potential verdicts, but they understand that these cases have to be litigated. These cases have to be defended by large corporations or small business. As a result, these trial lawyers are basically extorting and leveraging settlements as a result of what ultimately is this very vague act. So that's a little bit about what Consumer Protection Acts are. Now, the question becomes then, well, what can we do about it? The trial lawyers are circling, and the trial lawyers bar is very much interested in keeping the Consumer Protection Acts the way they are. Well, there are a lot of groups that are mobilizing in an attempt to get some of these Consumer Protection Acts amended, and in particular, ALEC, actually, our heroes, have their own Model Consumer Protection Act, with the intent of which is to reinsert those proof requirements. So reinsert the requirement that you made a false statement, and that you had an intent to deceive, and that you relied, and that you actually were harmed. And that the Model Act also removes a lot of those unfair penalties that current Consumer Protection Acts try to levy. Obviously, you can see the Model Act at alec.org. Follow the links to model legislation and civil justice. So I hope I provided a little bit of backdrop, not only about the crazy case that I had the fortune or misfortune to have to deal with, but also, more importantly, really how this can affect not just the chunks, but how this can affect business, large and small, and how it can affect real people and ultimately destroy their lives if this type of legislation isn't done away with, and if people like the Roy Pearsons of the world aren't discouraged from bringing this sort of lawsuit. So I appreciate your time, and hopefully if we can mobilize, we'll have the opportunity to make sure that the tragedy that was the now great American Pants case never happens again. Thanks, everyone.